This will be Praetorium Secured Fund versus David Keehan. It's case number 18CA011433. The appellant, Keehan, has waived oral argument, so we will just be hearing from, is it Attorney Klein?
No, Attorney Muscat.
Attorney Muscat on behalf of Praetorium. We've read the briefs, are ready to proceed. You'll have 15 minutes on.
Great, thank you, Your Honor.
And state your name for the record since I have Attorney Klein on my sheet here.
May it please the Court, Your Honors. Joseph Muscat on behalf of the petitioner appellee, Praetorium Secured Fund 1. Your Honors, this case is very straightforward and simple. It involves the issuance of a foreign subpoena by my client. My client filed a petition in September of 2018 for the issuance of foreign subpoenas in Lorain County Court. This petition satisfied all of the requirements of Ohio's Uniform Interstate Depositions and Discovery Act and the local rules of this court. The trial court acknowledged that the petition satisfied Ohio law, and the trial court properly granted the petition and allowed the foreign subpoenas to be served. 1 day later, the foreign subpoenas were successfully served upon the appellants. Instead of complying with these relatively straightforward and simple document subpoenas, appellants filed a motion to dismiss and/or motion to quash the subpoenas. In their motion to quash, they did not raise any legal arguments under Rule 45C of the Ohio Rules of Civil Procedure. They did not serve any objections to the foreign subpoenas, nor did they raise any issues related to the process or procedures for the issuance of the subpoenas. The appellants instead raised one false argument, that Praetorium was not a registered business entity in Ohio when the petition was filed. Praetorium filed its brief in opposition to the motion to quash. In its brief in opposition, Praetorium attached certified copies of the Ohio Secretary of State filing showing that Praetorium was in fact a registered business entity when the petition was filed.
Was Praetorium or was Praetorium Loan Fund registered?
Your Honor, Praetorium Secured Fund 1 LP was registered as a fictitious trade name of Praetorium Secured Loan Fund 1 LP.
In the state of Ohio?
In the state of Ohio.
Prior to the filing of petition for the issuance of foreign subpoenas. Sorry, jump.
Yes, Your Honor, that the filing happened in August of 2018.
Meaning the fictitious name filing as well predated the petition.
Yes, Your Honor, that's
Thank you.
correct. The trial court denied the motion to quash the subpoenas on the basis that Praetorium was a registered entity in Ohio. And the trial court correctly found that Praetorium satisfied the statutory scheme of Ohio's Uniform Interstate Deposition and Discovery Act. Appellant's sole assignment of error is meritless because Praetorium was a registered entity at the time the petition was initiated at the trial court level. Appellants must show that the trial court acted unreasonably or unconscionably when the court denied the motion to quash. They cannot meet this high burden. The trial court's order denying the motion to quash is reasonable and well supported in fact and law, for the very simple reason that Praetorium was a registered entity at the time of filing the petition.
Counsel, if Praetorium wasn't, let's just say it wasn't, would that have mattered in this case? Is that a requirement of issuing this type of subpoena?
I don't believe that issue has been addressed by Ohio courts. I would submit that I don't think it would be a requirement because you're trying to enforce a foreign subpoena in Ohio. And I think the rules under the Ohio Interstate Deposition and Discovery Act even allow for an attorney who is not licensed in Ohio to enforce subpoenas in Ohio without being admitted. So.
Thank you.
So for those very simple reasons, this court must affirm the trial court's order that allowed the petition to be granted and the motion to quash be denied. Appellants, in this case, attempt to raise an issue that is not presently before this court. In their motion to dismiss, appellants attached a motion for summary judgment involving a case of cognovits that is presently pending before Judge Bedleski of this court. Ohio law is clear that it's this court's duty to decide actual controversies involving issues before this court and not to issue mere advisory opinions. Like I mentioned, appellants improperly attempt to bring in and backdoor this legal argument regarding Praetorium in a case that is currently pending before Judge Bedleski. This court should disregard those issues raised by the motion for summary judgment because the record of that case pending before Judge Bedleski is not before this court. Since that case is still pending before Judge Bedleski, the defendants in that action may file an appeal from that court. A ruling on the issues on summary judgment in a case pending before Judge Bedleski is completely, both substantively and procedurally different than the issues before this court. And an advisory opinion by this court related to the issues in that summary judgment motion is improper and will prejudice Praetorium. For all the reasons stated here today, for the reasons in Praetorium's brief, Praetorium respectfully requests that this court affirm the trial court's order that properly denied the motion to quash, reject appellant's attempt to seek appellate review of issues not properly before this court, and tax costs of the appeal to appellants. Thank you.
Let me see if there are any questions, Judge Callahan, the counsel. And I don't have any, so thank you for being present today and for your argument. We will, just like the others, take this case under advisement, issue a decision in due course, and we'll make sure the courts mails you a copy of that decision on the day it's released. You can also keep an eye out on the Supreme Court of Ohio's website where our opinions are also posted. Thanks again for being here today.
Thank you, Your Honor.